Marjut Salokaner. She's a leading expert in data protection and privacy issues. She's a lawyer, of course. And she has been consulting to Nordic for a long time and should be well to speak about the legal possibilities to pool health data from various sources and across borders, which is, as you just heard, highly needed.
Yes. First of all, I must say that I'm very impressed with the UNI's proposal, and I think that I'm sort of continuing on the same lines from the legal perspective, and I'm convinced that the legal obstacles can be overcome. And from my previous life, at least, I can say that the IP concerns are perfectly are doable. You can do your IP contract, you can do everything from IP, both copyright and patent point of view, within the commons framework. You can even use IPs as a tool for creating commons. Data protection privacy issues are a little bit different. So and because of the new European legal framework, we will have to think in terms of that, and there's a little bit of negotiation still possible to be to be achieved, but not much. First of all, my title was How to Pool Data, because that's sort of the richness of the new data science, that, and as we heard from Denmark, the possibilities to really have a research and care infrastructure that uses data from all possible points. We have I'm sorry that I'll be repeating some of, at the end of the day there'll be some repetition. Data from official population-based registers, genomic data from researchers and from public research databases such as the ones kept by NIH. Then we have clinical data, we have patient records, data from quality registers, and then we have data from scientific journals. And for the last point, I must stress that for that, also the copyright legislation is of paramount importance in order to be able to have open access to scientific journals and to be able to use data analysis tools also for the texts in scientific journals, and to sort of link that with patient records data and other data sources. But I'm happy to discuss that more if necessary. As this coming to the EU framework, this we already went through. What I should emphasize is that now we are not speaking about directive anymore. This is regulation and this is law. And it will be directly applicable as law in all the EEA countries as of 25th of May. Oh, I'm sorry, it's 2018. And not yet. It wasn't. So it's that's where the timeline started for counting for the. And the purpose was to harmonize the data protection law all across the European Union. But since it has been the most lobbyist piece of legislation ever in the history of the European Union and EC, it was very, very difficult. And one of the sort of the most difficult points turned out to be research uses. And it was left for the last trilogue meeting to reach the compromises. And that's why there are maybe some sort of, first of all, there's much leeway for the member states. It's almost possible for everyone to keep their own laws, but not quite, but almost. And then there are some sort of hidden things that you may find in this 200 pages of law that is now out. But even though there are flexibilities for research uses, there's one red line there that I can sort of bring up, and that is the creation of European research area. Even though the member states are permitted to have stricter protection for data subjects in their national laws in respect to research uses. This protection may not and cannot prevent the creation of European research area, as stated in the Lisbon Treaty. And I will come back to this later with regard to, in particular, Swedish law. First, as Magnus already touched this point, when sort of the basics for data protection is that there must be a legal basis for processing personal information. There always has to be a legal basis. You can't license data protection rights. That's sort of when IP people talk about data protection, they think that they can just license them as anything else, and that in fact might be a convenient solution, but that's just not the case. So the legal basis for research uses can be consent, obviously, then statutory legal basis in the law, for example, for public interest purposes, for the whole sort of governmental organizations rely on that when processing personal data of citizens. And a separate legal basis is there in the Article 9, which covers also processing of sensitive personal data, such as health data. That processing is necessary for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes. And now I will shortly go through these different points. Consent is a little bit, it's stricter defined than it was in the directive. So the parameters for consent are stricter. And I can sort of, from the Nordic perspective, I can say that the ends of the lines are Finland at one point and Sweden at the other. And we will see. And I suggest that there might be some sort of a common Nordic approach to this too. First of all, like we all know, the consent must be informed and voluntary when it's called for. And then the regulation says that for sensitive data, the consent has to be explicit, well-defined, and well-defined to one or more specific purposes. It can't be open. How broad it can be is up to negotiation. General consent for future research purposes is not valid. This is already old law coming from the Working Party 29, but obviously it's even more so now with the regulation. And then an interesting point that all consents should be in line with the regulation by 25th May 2018 if processing of personal data continues after that date. So when you process personal data which is based on consent, you should revisit the consent and sort of check that it's defined certain specific purposes. These purposes can be widely defined. And in the regulation texts, in the recitals, it refers to the common ethical standards of the research community. And I think we are here to discuss that. How to define these purposes so that they can be useful. And there always must be possibility to delimit the consent to certain specific uses. So even if you have a consent which sort of covers lots of different areas, there must be a possibility to delimit to certain specific uses. When you process personal information without consent for research purposes, it is possible according to the regulation, given that the certain parameters are fulfilled. First of all, the general requirements for processing must be satisfied, which are the basic ones that already exist: the lawfulness, fairness, and transparency of processing, collection of data limited to the purpose of processing. But then it says that, which is very good for you, when there is data which is collected for other purposes, such as register data, further processing of this data for archiving purposes in the public interest, scientific or historical research purposes or statistical purposes is not considered to be incompatible with the initial purposes, presupposing that the conditions for such processing as provided in the regulation are satisfied. And I will speak shortly about these preconditions. And of course, when you are processing large amounts of sensitive personal data, as you probably all are, there must probably be a data protection impact assessment, which is regulated in this new regulation. This means that there must be a data protection officer who looks what are the possible risks for the data subjects during this processing of their data, and then if the risks, the data protection officer can't find ways to overcome these risks, the regulation says that then they must go to the National Data Protection Authority, who must help their data controller to overcome these risks. So the regulation sort of imposes obligation to assist for the National Data Protection Authority, which I think is a good thing. What is more are the further requirements for research uses, which is sort of interesting. In the recitals of the regulation, scientific research is defined as, it is stated that it should be interpreted in a broad manner to include technological development and demonstration, fundamental research, applied research, and privately funded research, and also studies conducted in the public interest in the area of public health. And this, at least the Swedish participants, will look at this with amazement, because this is much, much wider than according to the Swedish law today. But of course, this is not, because it's in a recital, it's not binding as much as the articles are, but it's sort of, it gives the general idea of the regulation. And so it's up to the national legislators to decide what to do in their national laws. And it will be interesting to see how this will come up in the Nordic countries. In Finland, there's a sort of, it will probably be defined very widely. In Sweden, I don't know, but more widely than usual at the moment, I think. And comment
on it when you're done.
Yeah, okay. And then the regulation says that in order to process personal data without consent for scientific research, there must be appropriate organizational and technological safeguards to secure the rights of data subject and to respect a data minimization in the course of processing. And I will go through these safeguards. And the starting point in this section is that at first place, personal data should be anonymized when it's processed. And anonymization in terms of the regulation really means that it's irrevocably anonymized. There can be no key anywhere. It's so that it's really anonymized. And when there's the key, then it's the pseudonymized data. And pseudonymization is given as one type of safeguard that can be used when processing personal data, in case anonymization is not feasible for the research in question. And of course, if you want to link data from various sources, you really need to pseudonymize it and not anonymize. But when handling, for example, those sort of massive big data, and then it's using anonymized data is, it's sufficient. And this is the sort of the definition of anonymized data. It means that the data is processed in a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, provided that such additional information is kept separately and is subject to technical and organizational measures to ensure that the personal data are not attributed to an identified or identifiable natural person. So the key should be separate. It shouldn't be in the same institution as where the researchers are. That's sort of preferable. And then this pseudonymization can be regarded as one of the safeguards. But it's not sufficient. You need other safeguards also. And one of the safeguards, I think, could be ethical review. It's not mentioned as such in the regulation, but obviously, and I think that Swedish law today is a very good example of how ethical review is used as a safeguard for protecting the rights of data subjects. It's obligatory, as we know, in all interventional research in the Nordic countries, and voluntary if no physical or psychological intervention is needed in all the other countries with the exception of Sweden. In Sweden, it's obligatory when research is conducted by processing sensitive personal data. And as we heard from Magnus too, it's currently considered also for processing of all sorts of personal data for research purposes. For biological materials in Finland, the board of the biobank may and usually takes the decisions, and there's no ethical review. It's sort of you can choose, or the need is considered there. Now coming back to my title of the presentation, how to pool data from different sources. Then we have to look what sorts of data you have. Some of the data is probably consented data, some other data come from other areas, from registers and such, without consent. And then as one good starting point is the clinical trials regulation, which was approved before the current data protection regulation, but is still not in force because of the the portal of the European Medicines Agency is still not ready. But there it says that there always, first of all, of course, you have to have the original consent for the clinical research, but then in the text, in the articles of the regulation, it says that a separate and distinct consent for matching clinical trials data to other sorts of research data, such as register data, is needed when this matching is done. And then it says, so this means that or can be read so that when data is collected by consent, other envisaged data sources should be stipulated in the consent if possible. And they can be very broad. They don't have to be very specific, but they can be very broad. And as I have seen different consent forms for different Nordic countries, and I know that in Sweden it's ethical review, or you have to have each register named. But in other Nordic countries you don't have to have that. And so there are different practices. But to have some sort of, and sort of, when we think of this from the European perspective, when we have this strict German practice at one side and then much looser practices from other. And from the point of view of the European Court of Justice, I think that this should be taken seriously and if possible sort of put at least the different data sources in the consent forms, if possible, if you already know them then. And then the data subjects must always be informed about the possible linking, whether it's based on consent or opt-out. The information should be there that the data might be linked to register data, for example. But this is sort of the basics of data protection anyway. But now that it's in the regulation and also the clinical trials regulation, it's the law. Now, from our point of view, from sort of a cross-border use view, this is sort of in a flux, or how do you say? We all must think how to do this, and I think that this cloud solution might be one. And the starting point, of course, is that the EU is a single market, and the purposes of establishing European research area is stated already in the Lisbon Treaty. And the GDPR, the data protection regulation, harmonizes the data protection laws. So it sort of presupposes the free circulation of personal data within the European Union. But access to official documents and secrecy laws are not harmonized. And this is sort of taking into notice also in the regulation. It says that access to register data is regulated under access to, first there's a recital that says, the sort of raises up the importance of register-based research, especially in the area of medical research. And then in the articles it says that interaction between data protection and access to official documents laws have to be reconciled at the national level. And for example, the current directive on the public access to public, on the PSI directive on public sector information directive, which sort of says that public sector information has to be reused, has no implication for data which is restricted on the grounds of data protection. And that's why this is left at the national level to see how to do this. And this is why member states are free to legislate on register-based research uses, as far as it's given in the, it stays within the GDPR framework. Now, there are some obvious problems. And I'm sorry to point to Sweden, but that's sort of how I, but I'm sure that these, I'm almost sure, let's see, I'm positive about this can be overcome. These local processing requirements, yes. I have run into them with, and these sort of concern situations where we don't have, for this is a Swedish example, on Denmark, when we don't have a local researcher or research institution involved, because the sort of the point is in the EU that you can collect data from various countries and you don't need to have a researcher in each country. But currently in Sweden, the ethical review law says that it's only available for research being conducted in Sweden. And a further problem is that then if you want to have Swedish register data, you can't have, first of all, you can't have the ethical review, and then the register hosting bodies won't release any data unless there is an ethical approval from Sweden. And it's the register hosting bodies who at the last instance have sort of the say whether they will hand over the data or not. Denmark requires an online access via Danish research organization, as we heard, for registered data. And this is not so. This is not the law. It's more the practice. there is one law concerning the central population register, which even requires that in the law. But I know Denmark has opened access to researchers from other EU countries and even US. So because the data sort of stays in Denmark and the access, it's an online access within a secure framework. And I have been thinking about this, and from the EU point of view, I've even discussed this with our Ministry of Justice, and I don't know their opinion today, but I think that enabling online access to register data for researchers based in other EEA countries would be sufficient in terms of GDPR, because it doesn't prevent creating European research area, even though the data as such doesn't circulate. But at least you have access to data and you may combine it to your own data. So online access could act as one of the technological safeguards, as you remember in the regulation. You have to have organizational and technological safeguards. And this online safe technological environment is obviously a safeguard. So this is the last slide. For creating a Nordic research area or even Nordic research commons, what we need, as in fact Juni said already, is common or at least interoperable national safeguards for providing access to register-based data for research purposes, both organizational and technological. And then only anonymized or pseudonymized data should be released for researchers. Any linking should occur by the register hosting bodies. That would sort of go what we have discussed, in fact, before already at Nordforsk. And this would be, in terms of GDPR, would be okay. And then statistical disclosure of data when it's obtained by data analysis of large data sets. Because there it's very easy to identify persons if it's you can't really pseudonymize it. And then common practical parameters for consents would help too, of course. Questions? Thank you.
I believe there was a comment in Magnus.
A comment or two, a couple. The first one with respect to the definition of what research is, I think stems from the Act on Ethical Vetting. And there they made a mistake based on that they adopted the OECD formulation, because there was an inquiry that suggested a very broad definition of research that would not be useful for the ethical board. So the government jumped on something to be somewhat sarcastic, found in the drawer, which was an OECD definition that says that research is experimental and theoretical work. They forgot observational research, which means that the ethical review boards never used that definition. It was impossible to use for what is being dominated in the ethical review. So they don't use that research definition in practice, and currently there is an inquiry that has the task of changing that definition. So that's already underway. But it was pointed out by the Central Ethical Review Board already in 2009. So it's been underway for several years. So that definition is, if you just read the law, it looks like a great problem. In practice, it hasn't been. The review boards haven't used it. The other, the thing about ethical vetting only for research in Sweden is a problem. But I think there you might want to look at it as research being conducted on Swedish observations. I'm not sure whether you can interpret it in that way, but in that case it would be possible for somebody else to do it, but you have to have an ethical approval in Sweden if you use Swedish data. So that might be a solution to that. The third thing is something that we've been thinking of, is that there are some preambles in the GDPR that talk about that consent is invalid if you have an imbalance between the power of the person or organization that asks for consent and the person that gives consent. For instance, as in the case of a public authority, it says. Now, universities are public authorities in Sweden. So the question is, can we use consent at all in university research? That has to be resolved as well. Our feeling when we look at this now is that consent is going to be maybe opposite to what the intention was, less important rather than more important in the future, according to GDPR, and that public interest is going to be the main way of accessing data, at least for public universities.
No more questions?
Then it's time to say thank you, Molly.
Thank you very much.
For your contribution. And